buying, selling, and sign a strata property. So I was asked to talk as much as I can in terms of details about stratas and selling stratas and buying stratas. And I've been just a little bit about myself. I've been doing real estate for 25 years, I think, and all kinds of real estate. So in terms of litigation, commercial, stratas, and also dealing with issues dealing within stratas. So I've helped clients deal with hearings before the strata councils based on bylaws that are unfair. I've also dealt with dealing on behalf of the council members and dealing with a particular tenant or owner of a unit. So anyways, all kinds of stuff. But without much ado, I'll continue on. So the first thing really is to know the strata. Know everything that you can about the strata that you're selling or buying on behalf of your client who's a buyer, who's a seller, and also if it's a property that you've been hired to manage, if that's the case. So you need to know a little bit about everything about where to find information and what to do with the information that you find. Okay, so a couple of things. There's all kinds of different stratas. Some of you have dealt with it exclusively in one or the other, but you may not have done all of them. There's townhomes, there's duplexes and triplexes, there's condominiums, mixed commercial residential stratas. There's also bare land stratas, and there's also a lot of different issues when it comes to brand new pre-sale condos and stratas as opposed to used ones. There's a lot of issues that come up with each one of these that are unique to each situation. One of the things, though, that I like to just talk about, because these are all different ones, and you might have come across, you may not. Duplexes and triplexes, I usually don't have an official strata management company incorporated in order to help with the management of the unit owners. They're self-managed, so that they have to, amongst themselves, keep track of common expenses and insurance and coverages and expiry. And it is, if you're trying to sell one of these or buy one of them, you're going to have to do some digging around to find out what is the situation with these people. And sometimes they have good records, sometimes they don't, sometimes they forget, sometimes they go, oh my goodness, insurance is expired, they got to buy it, or things like that. And problems occur when people who are living in a unit owner of a complex that's a duplex or triplexes where they don't get along and they don't manage things with each other. And there could be one party who doesn't agree and they don't pay. And then adjustments have to be made when a buyer moves in or when a seller moves out and they're selling or they're buying. So they have to adjust for common expenses being paid. Is there something being paid? What is the receipt? How much is paid for? What coverage is it? You know, there could be things such as landscaping contracts. It could be, most important is insurance. When does it expire? How much, who pays for what? So these things are really important things. And one of the things that is maybe not as apparent until you get to the closing date of a sale or buy is that oftentimes these owners have to sign the strata certificates that property management companies for condos would normally do for them. So they go to the owner and say, hey, you got to sign this. What is this? This is a Form F and a Form B. These are needed in order for buyers to know information about because it's still considered a strata. It may be different than a big development or tower, but it's still the self-managed strata. They still have to follow under the Strata Properties Act and give information appropriately. Anyway, so, and that might be strange. And when it comes to conveyancing and the closing, this is a situation that I get when I say, hey, somebody has to sign this. Who's going to sign it to say that there's nothing owing to the rest of the strata? Anyways, I just want to put it out there because quite often it's not that evident. And when you're dealing with a sale or a buy, it's good to know everything about this. What is managed, what is paid for common expenses, and is there a contract? Whose insurance? When does it expire? So if and whenever you get to that point, you're selling a unit or buying into a unit, know this so that you can find out about it. And then adjust for it or take care of it. I tell a lot of my clients who are moving into duplex or triplex where they have other co-owners is, do you guys have some kind of an agreement amongst the owners in order to make decisions? This is different than a strata. Maybe there's 3/4 votes for this or 80% that, but you have two strata owners and it's either unanimous or not. So you have that issue where you can't have 3/4 votes. You got to have it all or not at all. And so it's good to have certain rules. And sometimes it's kind of like a co-ownership agreement. I would ask these owners to prepare and write and do an agreement, which they would all agree on how to deal with certain issues. One of the issues that did come up was recently when they were trying to sell a unit, but before the unit was sold, a leak had sprung up, and the pipes that ran into this was a bare strata, the strata property where the two properties are not on connected to each other. They're a separate piece of land, but they're connected. The water sewage went to one and went to the other, but a blockage of one caused the blockage in the other, but it started in one. So you have to attribute cost and damage and expense to one house rather than the other, and how you define that. So it can cause a lot of issues. These are special situations that happen in stratas, which are duplexes and triplexes. Another thing too, quite often you have a strata complex where there's a residential section and also a commercial section. Well, two of them exist side by side. Usually the residential is on top and commercial is on the bottom. And that's usually two sets of maintenance, because the cost involved in maintaining one unit, one section is different than the other. And sometimes the owners are paid for both, or part of both, and strata fees cover them all. And there's a lot of disputes which arise in a lot of complexes between those things, in which one, for example, one case that I was dealing with recently was where elevator access to two levels of the mall is also shared with the residents further up, and then they're going to say, hey, the usage of the elevator is greater for the commercial because of all the customers going in and out, and then they think their share of the expenses should be less or more. Anyways, these are very common issues all over the place. Separate bylaws, of course, to manage the rules and govern the conduct of each section. So some of them are different, some are the same. It's good to know what is involved and if it affects the other units as well in the other sections. Anyways, it's very common, okay? Special problems that come up with these types. So when you're involved in selling or buying and managing, these are some of the things that you have to be aware of. If you have a strata property complex you manage, which is both sections, or if you're selling one and then you find out from the Form B that you order, hey, why is the residential tenant paying for a portion of the strata fees, a section dealing with the commercial? So it's good to know why when you explain it to your clients, or saying, oh, gee, why are my strata fees so high? And, anyways, something to think about. Next thing, spare land stratas. Of course, you do have these, and when you look in from these spare land stratas, they're stratified properties, but they have shared common expenses, and these are not like the walls and the pipes that go between the walls between the regular strata that's a tower, but they're like street lamps and sewage and water and power lines and these things that people share. They're owners of a whole bare land strata. Each property has their own insurance, so it's unlike the towers where they have one insurance company covering every unit. These are separate ones for each separate owner of the property, but they also have ones that are for the common facilities. If they have a clubhouse, for example, or some other building that the stratas use as a common property. Okay. So it's important to know that, and there's certain rules, because in the Strata Property Act, there's regulations. You don't find the regulations within the Strata Property Act itself. The regulations that are created in order to regulate certain parts of the Strata Property Act. So you have to search specifically for bare land stratas to find out more about them. For example, access routes are required, and if the bare land strata is close to water, for example, they have certain rules about how far you have to be away from the water in order to have public access. So there's all kinds of separate rules. If and whenever you're selling or buying or managing or thinking of developing, stratifying a property into a bare land strata. Okay. Now, where to find information? Okay, now you've got a client, you want to sell it, you want to buy it, or you want to manage it. These are the areas of places you can find information about your strata. All of these different ones apply to different stratas, and I want to talk about each one of them just a bit and give you some things that have come up in my practice which are relevant and important. First thing is, so there's 8 things here, and hey, Just like Stoic did, they want to make you listen and read. At the end of this, I have a prize too, if there's time permitting. I'll ask CREPA if it's okay with that, and I have a question or two that may come from the slide. So anyways, there's 8 different places in which you can search for information, and this is not an exhaustive list. This is just some of them. Title search, Form B's, information certificates, bylaws and rules, minutes, Strata Council meetings, depreciation report, Strata plans, and the court litigation area, civil resolution tribunal, and also the disclosure statements of new pre-sales. Okay, so I'll just go a little bit about each. First thing, title search. As long as the title search shows on a, when you do a search and it shows the word strata lot this and strata plan that, this is a strata. It may not look like one if it's standalone, it's like on a bare land strata, but it is a strata and it's not connected to another property, connected to each other, then it looks like a duplex, and quite often they can be, but look at the title. If it's not a strata, then it means it's 2 lots connected to 2 structures on one legal lot of land. If you do a title search and you find out it's a strata, then it falls under the management of the Strata Property Act and the rules there as well. If you do a title search and you see a Strata Property Act lien, not many of you have seen it, but it's not that common. You do see it from time to time and you wonder, hey, my seller has a Strata Property Act lien on it. What's going on? Well, it's a good sign your client seller owes money to the strata for whatever reason. There could be a bylaw dispute. There was a fine issued, not paid. Strata fees, arrears not paid. Maybe even special levies that are not paid. Quite often, is it by mistake or is it on purpose? Is your client, the seller, have an issue, a dispute they're fighting with the Strata Council about? This is a good sign that there's something is amiss. And not only is it amiss, something's wrong, it's serious enough that the strata actually put a lien on the unit owner's property because it's a serious matter. Okay, and so it's usually not a trifling thing if they put a lien on the property, because it takes money. It takes hiring a lawyer to a law firm or to file the lien on the property. So it's something pretty serious. And of course, you know, if you do the search and the order the strata forms from the Strata Property Management Office, you probably see it right there when you see the Form B. There's ongoing litigation. There's maybe perhaps unpaid fines and fees that are all disclosed inside the Form B. Okay, so when you do a title search and you see this, these are a couple of things to think about when you get there. Okay, then B, information certificates. These are very common. All these buyers are advised to of stratas to review and research and look at the Form B before they make a decision to buy, in addition to the other things that I mentioned of the 8 items to look at. What are some of the things that you can find out on Form B? Very informative, but of course, again, when you come to duplexes and self-managed properties, those are harder to get correct and accurate and reliable information. So immensely, you know, when information you can find out strata fees, what is to be paid, any amount that an owner owes to the corporation, any agreements that are made where an owner takes responsibility for expenses related to alterations to the strata lot, a common property, or common assets. Very common. If a property owner, for example, says, hey, I want to put an enclosure on my balcony, which is limited common property. Quite often the agreement is made, well, whatever happens, if there's a leak, if there's a problem, is an issue, it's the responsibility of that owner to make sure they indemnify the rest of the strata for problems relating to it. If you want to change it, you take care of it. And you can find that out in the Form B certificate. Other things, amendments to the bylaws that are not yet filed. These amendments could be changes to the strata plan or to the strata limited common property or things like that. Any amount that the owner is obligated to pay in the future, not just what they owe in the past. So they could have a special levy that's due in the future, right? Any resolutions passed by 3/4 vote or unanimous vote that is required to be filed but not yet filed. And important to note, because you know it'll affect you later on after you buy. So it's important to know these things as if you represent a buyer. And if you represent the seller, to know what you have to disclose to a buyer when they make inquiries. I've done a presentation, I think before, maybe with CREPA, about material latent defects, which is if a realtor knows something but doesn't disclose it to the client, even if the seller doesn't know. And these could be liability issues for the realtors involved, okay? Anyways, next thing, any notice has been given for a resolution that may propose to be coming into voted upon and become law. if there's a 3/4 vote required or 80% vote or unanimous vote. There's different requirements for votes in order to have different changes to be done in the strata. So if there's a notice that's upcoming, this is very important if you're acting for a buyer and you see this on the Form B and you want to inquire and find out what are they going to be proposing on that vote, and then manage it or take care of it when you offer, put in the offer, you put in the reveal, when you sell to a buyer and you know that's upcoming, you got to know how to deal with it before it comes up. So for any of you out there who, realtors, if you're selling and you're buying and say, hey, I don't, this is a Form B, it should be for lawyers to look at for the clients. But if you're acting on behalf of a seller, it's very important to know, like quite often sellers don't even know what's going on. They don't get themselves involved in the strata. They get the minutes, but they don't get involved. As long as they have access to the elevators and the parking's fine, no leaks, everything's good. I don't want to look into these things. That's very common. If you're acting for a seller, then you should actually, get the clients to actually look at it or look at it yourself to know ahead of time so that you can foresee issues come up before they happen. Okay. Is it a resolution to increase the maintenance fees to pay for certain repairs, things like that? You need to know all about that. Okay, next, any wind-up termination resolution. There's a lot of these very, very old stratas that may want to sell to a developer, so this is very important. The number of stratas that are rented, that's very important. A lot of people are investing now and they want to rent it out. There could be restrictions, so you want to know whether you can or cannot rent it out, or if there's a grandfathering clause, or if there's somebody who's about to give up their rental pool and to put it back into the pool. Details about parking stalls and storage lockers allocated to strata lots and their numbers. It's important to know that strata management companies, especially when they change and the records are transferred from one to another, it could get lost. And then they do get lost. I know one of your CREPA members, I won't name any names, but you have this very horrendous issue where somebody owned the parking stall, have been known that they owned it for 20 odd years, and then when the strata managers change and then, no, you don't, you only have one, and you have to, you can't use that one because it's you're gonna already be fining you. And then to dig it all up and find out and research and argue and litigate practically. Unfortunately for that, I know one of your CREPA members had to deal with that. I won't name names, but when they consulted with me on that, it was very fortunate that the strata management company realized their mistake and then corrected it. Otherwise, you're selling property was two, but then you find out that there was only one, and you can be liable for misrepresentation and breach of contract and compensation for the loss of a parking lot, which could be thousands and tens of thousands of dollars nowadays. Anyways, moving on. Bylaws and rules. These are very important. One thing to know, what is one and what is the other and what is for. So bylaws govern the use of each strata unit, such as pets and rentals and also common areas. But rules deal with the use of the common areas and are such as the rec room, but the owners do not vote on the rules. So the owners do create the bylaws and decide the bylaws, but the rules are created by the strata. Okay. And of course, again, I said earlier, there's different rules for different sections, okay? Now, one of the things I want to talk about is also about lifestyle restrictions. These are very important. I have certain clients, especially nowadays, where they're downsizing. They're looking into places where not younger families, but older families can live in, like for example, 55 years and older or 65 years and older. Very important to look into those bylaws as a buyer or seller, because it could be very well be, and it has happened, and I've been dealing with it a lot, where the owner also wants to deal with what happens if they pass away. And I did a CREPA seminar on financial estate planning and finances when it comes to real estate. What happens if they pass away, or if it's a joint tenancy, which is quite often done, so that it can go directly to a child. And then it hits into the bylaw restrictions where an owner or resident has to be 55 or older. And then they may be forced to sell. For example, I'm going to switch this one to this part. This is what I'm talking about, downsizing seniors. And then these are the problems that occur, because all of a sudden you have a unit which you can't live in, and you have to sell. or in a particular situation, or the inheritance of the unit, they have to sell, and they can't live it and they can't rent it out. And it's a very limited pool of people they can rent it out to. So this is a very common thing nowadays, is much more common to be aware of. So lifestyle restrictions regarding age. But the other thing dealing is pets and families as well in terms of age. The other thing I mentioned here is rental restrictions. We mentioned that before. Quite like 3 or 4 years ago, it was the rage where every single other consultation I had for strata plans or corporations or the tenants themselves or owners is short-term rentals. Unfortunately, if depending on who you are, a lot of the fights and the court rules and court rulings that had to occur to give clarity has changed now. Short-term rentals are now, everybody knows they're not considered under the Residential Tenancy Act, and they're licensees and they're not tenants, and therefore all the loopholes have now been changed. So most bylaws should have been amended by now to reflect and restrict against short-term rentals like Airbnb, etc. But there may be some that have not taken that step. And so you as a seller, maybe as a buyer representing a seller, it's good to check in to see whether the bylaws have been updated enough, sufficient to deal with that. Either you want it or you don't want it. You want to have a building that promotes it as income for its owners as an investment, or be restricted because some of the owners and they don't want strangers coming in and out of the property. Very important. Insurance coverage is very also important to look at and to see if there's any overlaps and conflicts. It's all over the place sometimes, quite often, and these issues come up all the time. And recently there was a person who was selling a unit, and there was a leak next door before the sale completed. And then there's also issues then, whose insurance is supposed to cover and how are you going to cover the repairs and who pays for the deductible. Very, very messy issues that deals with Stratus in particular. If you ever had to encounter that while you're selling or buying or managing, the insurance issues, and we can talk like a whole couple hours about insurance coverage and how they deal with it on another topic and another day. Fines and enforcement of fines and penalties. We mentioned a little bit about that. Strata Property Act liens and how they put on title searches and what to do with it. But one of the things is known, I'll give you a little segue. I had a client who had a complaint that their number on their unit, their strata unit, kept falling off. And they 2 years of waiting for the strata company to get a caretaker or management guy to fix it. They went to Home Depot, got their number 9, brought it to the replaced it and banged it in. They got dinged a fine just before they sold the property. It's like a little small thing, but and then they agreed to hold off on making sure that they receive payment of that fine until they do the sale. So, and then you think about it, like a $200 fine for a number on a strata unit. You know how long it took before they resolved it? 2 years. And the reason is, okay, the strata has withheld a hold back on the fine, and they wait till they resolve it at a strata council meeting, but it's really low on the totem pole of concerns of the strata. They kept on pushing it over to another strata meeting, next strata meeting. They got more important fish to fry, and then nobody gets to resolve this issue until 2 years later, and the $200 is released. You have a Chinese saying, just forget about it. But 2 years later, right? Crazy. Anyways, you might have that. And if you've ever come across with bylaws and fines and, the stratas require those to be paid up or dealt with before completion happens. So we mentioned about lifestyle restrictions, rental restrictions, short-term caps and bylaws. We also talked about insurance and who pays the deductible and who covers the repairs. One of the things that I tell you I guess you call these war stories, where I acted on behalf of an owner of a commercial unit, and where the upstairs unit had a leak, and the waters came down and flooded my client's apartment, a commercial unit. And so we said to Strata, hey, is it the Strata problem? It's in a pipe inside the walls. Is it the owners upstairs because it emanates from upstairs? Who's going to pay? And Strata says it's not our fault. It's the Strata unit owners above us, my client, that they should be at fault. The Strata unit owner upstairs says it's not our fault. We don't know what happened. There's a leak somewhere in the, someplace in the pipe, someplace. So, and then there's a dispute. At the end of the day, what is my client going to do? So we sued both of them. We sued both the owner upstairs. We sued the strata for the responsibility to take care of things. During the discoveries on the Supreme Court, we came across and we ordered and requested and subpoenaed all of the expense records of both the strata and as well as the unit owner upstairs. And lo and behold, we got a receipt for a Roto-Rooter that went upstairs and they dug out disposable cat litter from the upstairs toilet. Ta-da! Okay, we have causation, and it caused a backup in the sewage and the pipes, and then we have liability. But people are, insurance issues and comes into play. Everybody wants to deny responsibility until you sue them and find out what it is. It's very, very messy. Okay. Yeah, there's a case I wanted to bring up dealing with deductibles. Quite often, the insurance companies for the strata would pay the deductible, but the insurance coverage of the unit owner that's responsible, if the source of where the problem arises in a part of the unit of a strata that's exclusively used by that strata owner, it's that strata owner's responsibility, even if they could not have reached into the pipes or the wires or the whatever the issue that caused the issue. And so is even beyond the control of that unit owner, but it's their exclusive use. That's an important distinction. You use it even though you can't control it. It's that unit owner responsibility. It's kind of, think about it, sometimes unfair. Well, why is the unit owner responsible if they can't even maintain it? They can't open up their walls and dig inside and fix a pipe or something like that. But anyways, this is the analogy is that the case that I put up here on your screen is that they can't control the tenant who caused the fire, similar to that. And the owner says, not my fault, but it's something that happened in the area in which you are exclusively using and you had control. You're responsible, no matter if you didn't cause it, okay? There's other issues involved. We can give a long discussions into all the nuances, but I just wanted to put this as a general principle of rule in case you ever have a selling client or a buyer or client coming into one and there's an issue like this that comes up, okay? Enforcement of fines, of course, when you sell a property or buying, you need a Form F from the strata in order to allow the transfer to happen at the land title office. If nothing has been arranged, arranged to pay for it, well, then the Form F is not issued by the strata. Okay. And quite often it comes to the part of the law firms between the buyer and seller to deal with this particular issue. The strata places an undertaking on the lawyers to make sure that something gets paid. And if you think about it, your buyer wants to pay themselves and they want to write a check and give it to the strata, and the strata has an undertaking from a lawyer to pay. Which do you think the strata would prefer? A check from a unit owner that may bounce, or a strata undertaking from a lawyer that the lawyers can be disbarred for if they don't undertake and follow up with that undertaking. So of course the strata usually says, hey, we'd rather prefer the lawyer's pay rather than the unit owner having to pay for something that's owing to the strata. Okay, just want to let you know. One thing too about bylaws and fines, and you got to make sure that is a fine fair or not. Say you've got a client who's selling a property and they got a bylaw fine, and if there's enough time to deal with this problem before selling, you might want to check to see if the fine was even assessed properly. So recently I had represented a commercial unit in Richmond where they were fined, and when I looked at the process and the procedures that they followed to fine my client, it did not follow the Strata Property Act rules. They did not give a complaint to the client, didn't give my client an opportunity to respond, and then didn't give my client an opportunity to have a hearing before the Strata Council before making a decision. So we managed to get it all canceled, but at the same time moved. There's a whole Strata Property Act regime that deals with rules before stratas can fine. Okay, just want to put it out there. Next thing is minutes of council meetings. There are 3 different kinds. You have regular ones that happens every month, AGMs, which are annual general meetings for all the owners, and special ones, which are all the owners are called because of a special emergency that has arisen. These are all sources to look for information. Now, one thing to look at is, next slide here, right there. Council meetings, what to look for. persistent problems, leaks, break-ins, bylaw violations, unpaid fines, troublesome owners. You go through the months and months, and there's always one unit owner that seems to be causing all kinds of problems and not listening to the laws and rules and bylaws, discussions of future repairs, discussions of investigations or complaints. This is really important, this last one, because quite often I've been asked to review meetings and minutes in order to advise a potential buyer, is that there's discussions, but nothing happens. Like, resolve, investigate. But you go months and months and months, and nobody has a resolution of what was investigated or what was the result of the complaint or how it was dealt with. Then you have a proactive strata council, which, you have, I remember this one strata, which was all engineers. Practically everybody living there was an engineer. They were on top of everything before anything happens. Depreciation report, done. Every 3 years, done. Because they know the value of these things. But then there's others which are perhaps maybe all owned by seniors, where they're not into the intricacies of the maintenance and upkeep, and they have fixed incomes, and they're not into fixing things before they get a problem. So that's an interesting thing, but important to look into. These are all different things I look at when I represent clients looking into these things. I mentioned about follow-ups, repeated waivers of depreciation reports. That's could be worse than if it's an older unit. If Strata's 30, 40 years old and they don't have one, or they're supposed to do one, and then since then they haven't redone them every 3 years. They keep on waiving it and waiving it. It's a red flag, okay? Fishy or convoluted wording, because everybody knows that whatever they decide upon will end up in some kind of a minute that other people can see. And this happens quite often when there's a power struggle happening amongst the council members, and they have a vendetta against somebody in their owner in the building, and they want to say something but not really say it. Okay, this is because if they say it, they will get in trouble. So anyways, this is interesting. Fines assessed to owners have not been paid. Special levies, these are all important things to look for. Fines assessed to owners have not been paid. I mentioned a little bit about that. Sometimes there's holdbacks and it take years to take care of. I mentioned that already. Special levies. Now, this is a very special situation. You have to deal with it. If there's something being proposed in the future, and somehow it wasn't mentioned in the purchase and sales contract about how to deal with these, and it does happen. You look at the bylaws, it didn't see anything funny, but there was one little mention about a proposed AGM in the future to deal with something that requires a special resolution, special levy, and how to deal with it. So, normally what happens under the Strata Property Act is the seller will owe whatever is owed to the strata before the completion, and the owner, the buyer coming in, will be responsible for whatever happens afterwards. But this can be negotiated. So quite often, you can put this as an example in your contracts. Special levies approved before the completion, after the contract is entered into, but before, the seller will credit the buyer with the entire portion. So you can negotiate this if you're acting for a buyer. Of course, if you're acting for the seller, well, you want to deal with it so that the buyer would pay part of it, right? Be responsible for it. And you want to make it blank and have the buyer be paying for the portion that it becomes applicable afterwards. But my advice for anybody buying, selling, is to know what you're selling or buying, and also to deal with it, and not to let the act or the law deal with it, okay? Because that can lead to a lot of problems. Something negotiated and contracted for a special terms, black and white, is much better, okay? Next one. Next slide. We have later on, sometimes the strata, of course, you buyer and seller sign a contract. They're not signing a contract with the strata. You got to remember that. Strata finds that there's a refund, they didn't use it, or they should have used it, but they didn't, and how to get that money back, where some of it is coming back. Where does it go? It goes to the current owner at the time in which they do the refund. And it's very hard to go after somebody who's got something afterwards. So just remember that this is their contract is not with the strata. They're not they don't have an obligation to track and track down the agreements between buyer and seller to give a refund to someone else, okay? So another thing, another council meetings, next one, depreciation report. I mentioned it a few times already. It's really important to know the 30-year span for calculations of future costs of things to fix or maintain. And it's very important that they're expensive though. Has to be done every 3 years, and it's required for every strata corporation that has 5 or more units. So you have a duplex, not there. Triplex is not required. Anything 5 and over, then you get into this problem. But it can be waived. So 3/4 of the votes at the AGM can waive it, and I've seen many of them where they do waive it, and because it's expensive. And then think, 30 years, that's okay. But if you have a very old building, it may be something to a red flag. Somebody should be doing something about it. Next one. Next slide there, financial forecasting. There's 2 sections of financial forecasting section, how much the future cost of these repairs will be. And so that's important to know what the potential cost will be, and if there's enough money in the contingency reserve fund to take care of those things in the future. But there's also a physical component, inventory and evaluation. The elevators, stairwells, roofs, plumbing, they look at those facilities and see how much time it would take before they fall or they break up and don't get used and needs to be repaired. It's important to know these things. Then number six, strata plans. What can they tell you about the property you're selling or buying? Okay, so it's a very informative thing to find out, because some of the things you need to know is very important, is whether something in the property is common property or is it limited common property. Common property is usually their hallways, elevators, recreational amenities, buildings, exteriors such as the roof. And the common property can be a parking lot as well, in which the strata can vote and to move and attribute and allocate parking to different people and the owner. A 3/4 vote is required to amend or allocate common property. So another thing is limited common property. What is it? Where is it? How is it dealt with? So usually these are different areas of the strata that are used exclusively by one or more of owners, and to the exclusion of most everyone else. Balconies is one of the biggest important ones where you can find out on a plan. It's designated as a limited common property. Patios, parking lots, storage lockers. And then in order to reallocate or amend or deal with these limited common property, it requires a unanimous vote in order to change or move these things. And it attaches to a strata lot. So, if you sell a home, it's the LCP with the parking lot, or then it goes with the property with it. So when you sell one, you sell the other. You have to be careful. There are some stratas out there that they separate them, and you have to buy the parking separate from the property. So you got to search the plans in order to find out, confirm. And I've had situations where the strata management company recorded it down wrong. And so when they issue the Form Bs, they were wrong. And then you look at the strata plan, and it shows, oh my goodness, this strata is limited common property. You can't just, 3/4 vote and amend it and then reallocate it, even if they did it, and they could be wrong and could be liable for doing something they shouldn't have done. A quick search of the strata plan, make sure that there was never a unanimous vote to change LCPs, then you can confirm that, okay? You got to be careful about that and watch out for it. So one other thing, parking lots, I mentioned a little bit about it, and sometimes they miss out, change it. Places to look for where and if a parking lot, the first thing is the Form B, because it'll say whether it's limited common property or common. There should be there. Not only is it comes with the property, but how is it coming with the property? Is it because it is a common lot, common property that was assigned, or is it a limited common property that was assigned? And then the future protection of how that parking stall can be protected in future sales and purchases. Okay. Next one I have is just a little sample. You have this strata plan that shows things are with a big C with a circle. That's common property. And then you go to another one where you have limited common property. It's hard to see here, but it says LCP right on that little yellow spot over there, and you'll see it. C with a circle and LCP capital to know it's something somewhere, some places a limited common property or not, from the pre-sale or an existing strata. Okay, this is a sample of a bare land strata. So you have separate lots you'll see, and of course, if you see my cursor there, lots, and you have a lane that connects. One of the rules about the spare land stratas is they must have access. You can't have one without no access by car and vehicles to go and access each of these. And sometimes when you do the plan, you realize there's one lot in the middle of all these other lots nobody can get to unless they have a right of way of some sort. Not a good idea. Okay. I think I dealt with the property in Penticton where they had a mountain and a road going up the mountain to the unit. And then didn't realize until everybody searched that the road isn't accessible by everybody, but I belong to the owner at the bottom of the mountain who can just say, nope, sorry, it's my land, my road, you can't go up. Big problem. Anyways, litigation, lawyers, okay, this is like hand in hand, become two like salt and pepper. But anyway, civil resolution tribunal, specialized tribunal, specialized for dealing with strata disputes. The idea about this is that it was clogging up the regular court system, small claims court and things like that. And so they created a special one just to deal with strata disputes. It's not all they do. They have a jurisdiction of claims under 5,000, but small claims matters under 5. But a lot of it is plugged up with these particular types of claims and battles between stratas. And it's not a court, so the rules of evidence is very, very different. You bring up whatever and anything you can to call it as evidence, and then neither is a hearsay or objection, Your Honor. No, none of that. All that stuff you see in TV doesn't apply into CRT. Okay, so you can look for past decisions. Now, this is important. Recently, I had a client that was selling a unit, and then the buyer, wow. They did a search. This is a commercial one, by the way. Did a search of and they noticed that he was sued by the previous stratas before in the past. It's like, wow, interesting. So anyway, CRT website, I've got the link here. You search the strata plan, and then you can see whether the plan is involved as either defendant in an action or as a plaintiff. Okay, if the strata sued a unit owner or being sued by a unit owner against a strata for something they didn't or should have done and didn't do, or etc. CanLII, which is it's cross Canada. It's not just CRT. It includes the CRT, but decisions in Supreme Court and provincial court. And you search using the strata plan. And then see what cases come up, and you can take a look at what happens and how they get resolved. And of course, these court services online is for ongoing cases. So somehow it's launched, but it hadn't made it yet to the strata minutes or anything about what's going on with it. It's not yet a decision, so it does not show up on CRT or CanLII. You go there, you type in the name and see if they've been suing or being sued, right? Okay, so a couple places to look at. And then finally, I'm going to talk about disclosure statements for pre-sales, because there's a particular form of stratas, very common. And the idea is that there's an obligation to disclose important facts to a potential buyer. And failure to provide these in a disclosure statement that are material or devise of the buyer of a material fact can be a cause and maybe entitles the buyer to rescind the contract. And these are defined by the Real Estate Development Act, or REDMA. And next one, it said material fact is something that proposal or doing something that affects or could reasonably affect, be expected to affect the value or price or use of the development unit or development property. That's the most common thing, that if anybody was to say, hey, I want to back out because of this, because of that. But there's also other rules that deals with material fact. One of the things is that it has to be objective. You can't be just say, I feel it's important. It's not that. You need objective evidence to say objectively, evidence to show that whatever that the change or the proposal is so important that it can be measured, right? It can't be a subjective in terms of feelings. It has to be measurable, okay? And it has to be a material. It has to be significant enough. And then there's a couple of cases there that give some definition. There's not a whole lot. You have to look at the case law, but it gives you some guidance as to what is or what is not. But there's some other rules too that came recently. Whatever it is that the fact, the material fact is, it has to be a reason in the buyer's decision to buy, and it's not an afterthought. And also there's a limitation period also. If you want to use a material fact to rescind the contract, there's a time frame for 1 year after the completion, okay? If you find out something that you weren't told and that you want to back out of it, okay? So there's a specific things. One more thing, the buying and selling a pre-sale when it's a strata, very, very important things, especially for brand new ones nowadays. And I will bring these two topics up because they repeatedly happen over and over again in this context of these pre-sales that are being bought and sold all the time. Account for the GST, so important. GST has to be paid by the assignee based on the purchase price of the assignment, which includes the profit and the lift, and the inclusive of the deposit is on top. And quite often, if you're not careful about it, it's not written in. And then the buyer, and the assignee, when they go and buy later on and complete, they have to pay GST on the price as well. And if they always intended to invest and not to live in it, they turn around and sell it. Or if it's always been empty and they wanted to live, but they didn't live, but then they sell it because they don't need it anymore. And then GST are charged again to a potential buyer. So if it's absent on the contract when you sell to helping a client sell who just bought a brand new pre-sale, then you have to account for the GST. So things to do when you get that situation, if acting for the seller when deciding on a listing pricing, factor in the GST. And when you're acting for the buyer, you don't want to be responsible for the GST. You put in prices to include GST payable. But the thing about it is, if you forgot about it and you didn't do it, and you include the GST as part of the price, and you pay the price for doing that, you can apply to the GST office to see if you can get a refund. And that's a process which you ask an accountant for, but I've been told that there's a lot of tests that the CRA will use to see whether you can actually get a refund or not. So anyways, there are documents that between buyer and seller that they have to have the seller sign prior to a completion. They're called Gst Certificates, and the seller is required to sign off on whether it is applicable or not. And if there's no little section that says unsure, it is or is not. There's no place to say do not know. And so, if you don't know and you say no, or you don't know and you say yes, you could be liable for not being sure and what your GST status was as a seller. Okay. And misrepresentations or lawsuits based on being willfully blind. You knew that you should have been applicable and you didn't collect it, and why not? CRA will hold both the buyer and the seller liable both ways. The seller is supposed to collect, the buyer is supposed to pay. If neither one happens, they'll choose whoever is the most easiest one to get with access. And so, if you're unsure, and you always can get an advanced tax ruling from CRA before selling, so they can look at all the information and evidence that you should try to prove that it's not applicable before you sell it or not. So, you get some clarity. It costs money, it's time. But I think it's worthwhile to know what you're selling before you sell. Anyways, or else, if you're a buyer and you don't know, and you just put in, it includes GST, and then you don't have to worry about it. Okay. Be aware of how assignments affect property transfer tax. This is, not as common as a problem, but buyers who get really upset because they were hoping for the exemption based on the price that they're buying for the new home buyers of a pre-sale rebate or exemption from the property transfer tax. And then they buy an assignment thinking that, oh yeah, the unit is $750,000. And I'm going to get this unit and pay the assignment price. And when I close, then I get $750,000 to pay at the end, and I can claim the grant because, hey, it's $750,000. The PTT office will look at the assignment price, add it on top of the purchase price as an assessment of the market value of the home. So be careful of that. And you get audited and you claim the exemption, and later on the client pays, and then they get upset because they weren't told about this when they bought the assignment. So it's very important to know. Okay. There you go. That's all. Oh, geez, my goodness. I did it within 48 minutes.
So right on time, Ivan. Thank you so much. But before you go, there are a few questions on the chat box there. I can see Kathy asking that, does PTT apply? Already answered from your last page, right?
Yeah.
Yeah, okay. Another question is, will the law presentation be made available to us?
Well, that'll be for, for CREPA. I'll do anything for CREPA, right? So you guys have it. You guys give it to your members, and then it'll be available from CREPA. So
yeah, there's a number 604-817-7063 to call.
No, that's my cell phone too. So, but don't give it to clients. Just you guys. Okay.
Okay, another question is, how is the rules of evidence differ in CRT?
Well, the thing about it is that it's a tribunal, so it's a fact-finding mission. So whatever information is practically everything is taken, everything comes in, and then the fact maker decides what is relevant, what's not, what's important, what's good, what's believable, what's not. So the idea is that, certain in rules of evidence in court, certain evidence is reliable, some are more reliable than others, and some are allowed to be admitted for certain reasons. For example, admitted it for proving a fact. So if you say, I heard from John that this is not right, well, that's hearsay. It's not provable, the fact that something is not right. So that would not normally be allowed to be used as evidence in the court for proving something. But in these ones, you can have emails, you can have text messages, you can have pictures taken and conversations with neighbors of the units, et cetera, and then they're all accepted. Of course, the tribunal member would decide, yeah, well, okay, oh, sure, maybe not. So
it's better to take a copy from your cell phone text message for record purpose.
Oh yeah. So there's some for CRT, the text message, and important to keep a good documentary evidence. And whenever I represent clients, I make sure that it's all itemized and where it's from, who made it, and if there's anything to authenticate the making of it. So if you're gonna take a picture, hold up a newspaper of the date, and then you have Vancouver Sun date, the picture of you're taken. So these are different things to give a bit more reliability and credibility.
It's very smart.
Yeah.
Okay, one last question. Is there a problem Strata council member and then they sell, so they don't have to bear responsibility for their shady dealings and abuse of power? Does Strata have grounds to chase them?
I'm not quite sure the first part.
Yeah, I don't know. Probably she is referring to one of the Strata member, also owner of the building, and then selling their own unit. I'm guessing.
Yeah, I'm not too sure. I think you need a little bit more details before I can render a decision or an opinion on that.
Yeah. Anyway, thank you so much, Ivan.
Oh, I did say that there was a prize. Do I have time to give a prize? Is it okay?
Yes, go ahead. And the prize, the rule for the prize is members, they have to put in the correct answer, followed by their full realtor name with the V number. Okay.
So yeah, and pretty soon when we do this in person, I can actually give a physical prize. But I'm gonna do one. It'll be like an Amazon gift card. I'm sorry, but Amazon's great because they refund so easily. I wish there was a Canadian and Amazon just Canadian. But anyways.
Okay.
Neither here nor there. Okay, so the question is, what percentage of a vote is needed to change limited common property usage?
Oh, this question is easy.
Is it too easy? Okay, you want me? I think I was told to make an easy question earlier. I think.
Okay. Let me see. Do we have any answer from here? We have our host looking at it.
What's the right answer? 75?
Okay, the correct answer is at 75%.
Nope.
Oh.
No.
Oh, then this is a difficult one. Let me see.
What's the right answer?
Do you see any correct answer there, Ivan?
Oh, I don't have it open. Does anyone say 100%?
Yeah, we got it 100%.
Jordan Lane.
100.